short lecture, and we are going to discuss Arepee Industries Limited versus the Commissioner for Inland Revenue Services. It is a Natal Provincial Division case, and it was decided, or certainly reported, in 1993, which is very significant because 1993 was the year that the interim constitution took effect, and you will recall that the final constitution took effect in 1996, some 3 years later. Now, one of the provisions in the Bill of Rights, which are fundamental to the Constitution, is Section 33 of the Constitution, which reads very clearly that in the event that a decision which may have an effect on any party is taken, the official who takes that decision, and I'm really colloquializing the language here, is obliged to give reasons. Well, of course, Arepee, which is quoted as saying the following things in your textbook on tax administration, and particularly at paragraph 5.2 and 5.12, the Arepee decision is quoted in the following context, and it says as follows: unlike the taxpayer, the Commissioner does not have to show his hand before the hearing in the tax court, and may rely on any ground at the appeal. In Arepee Industries Limited versus CIR, Galgut J., who is a well-known judge from the Natal Provincial Division, observed that while it is by now well established that the Commissioner is not obliged to disclose his grounds in advance of the appeal, any facts that he may wish to rely on must be placed before the court by calling the necessary witnesses, and any documents he wishes to prove will also have to be put in through such witnesses. It will be in the course of the hearing at the latest that the taxpayer will become aware of what facts and submissions the Commissioner relies upon, in short, his grounds, and the taxpayer will thereby be left in no doubt what prejudicial facts or submissions he will have to meet in presenting his case in the appeal. It is at the hearing itself that the Commissioner case must be presented, and it is only what is raised by him at the hearing that is of any relevance to the matters in issue. It is this connection, in this connection, the Commissioner's reasons are totally irrelevant, for it is not his reasons that are in any way at stake in the hearing before the tax court. And then at 5.12, this is in fact repeated, and it is again observed that in Arepee Industries Limited versus CIR, Galgut J. observed that while it is now well established that the Commissioner is not obliged to disclose his grounds in advance of the appeal, any facts that he may wish to rely on must be placed before the court by calling the necessary witnesses, and any documents he wishes to prove will have to be put in through such witnesses. Well, this case was decided in 1993. 1996, the Constitution changed this situation dramatically. So the reference to this case and the support that is drawn from this case in suggesting that the Commissioner does not have to provide you with any reasons at the time of the assessment, in my personal view, is 100% incorrect. You will recall that we have and will be speaking about the letter of findings, which again is a process that is not legislated in any of the tax legislation in South Africa, but it is in line with the legitimate expectations doctrine, which we discussed in the last short talk. It is a practice which has taken effect from roughly 2000 by the former Commissioner Pravin Gordhan, whereby he gave the undertaking that in line with the Constitution, in the event that any major decision, which is the issuing of a revised assessment, is to be taken by the Commissioner will put forward the full facts as well as the law and then the reasoning it relies on in arriving at the decision which it is about to take, in order to give the taxpayer, in line with what the Promotion of Administrative Justice Act requires, an opportunity to respond fully to that, hence the letter of findings. And so it is very important that the Commissioner makes well known what his reasons are, even before he issues the revised assessment, which is at the time of the letter of findings. And then, of course, once the revised assessment has been issued, you will find out and know that in terms of Section 107A, regulations have been promulgated, and in terms of those regulations which take effect from the time of a revised assessment, at the time of the revised assessment or shortly thereafter, the taxpayer is given the opportunity to ask the Commissioner for his reasons. And if there were to be any difference between the reasons which the Commissioner gives after the issuing of the revised assessment and the reasons which he gave at the time that he issued the letter of findings, and there is no intervening piece of information or event or happening that helps the Commissioner justify why those reasons are different, one would be able to draw the necessary presumption that the Commissioner has acted in an arbitrary fashion. So, in my view, it is absolutely wrong to suggest now, in line with the Arepee decision, that the Commissioner does not have to furnish you with any reasons other than what is presented by him through witnesses in the income tax court at the time of the tax appeal. So if this particular piece of law is presented to you as it has been in the textbook that has been prescribed to you, my view is that that is not correct in law anymore. This was the common law position in 1993, and certainly it does not take into account the changes that have happened on a constitutional basis. Now, at the time, during the time that I've been talking to you, in front of you has been the LexisNexis page, opened up to the Arepee judgment. As I've done previously, I ran a search here by going to the advanced search form, and I just want once again to just take you through this particular process. And when you want to do the advanced search form, type in the word Arepee, type search, and what it will do is it will throw up a number of 27 hits where Arepee appears in the LexisNexis library. And what I did is scroll down to the actual case itself, but you will see once again there are many references here to the case, and what may be very useful for you to take a look at is to look at where Arepee has been relied upon in the SARS practice manual, and just to see how they've effectively used and made reference to this particular case, something that you need to actually look into yourselves in preparation for part of the preparation for this particular course. So I wanted to just clarify that point on the Arepee judgment. That is all on this lecture. Until next time, goodbye.